Hi, everyone, and welcome to what shall be the second of the asynchronous lectures concerning property. And in particular, we're looking at the law of real property. So, if you will, this is kind of real property 2. Before I get into the next discussion about the law of real property, I do want to address briefly with you exam number 2. I'm in the process currently, as I record this, of finishing up the grading of the subjective responses on the second exam. Scores on the objective portion of the exam were not as high as they were on the first exam. I tried to give a little bit of forewarning to you that the exam 2 material is the most complicated material that we cover. And so those of you that did well on it should feel very, very good about that. Don't rest on your laurels. And you'll want to prepare for the third and fourth exams. But those of you that didn't do as well on it as you would have liked to, don't be dismayed. Look at the score in total with the essays. Recognize that I'm looking at some of the questions to make sure that they were fair. There'll be probably a little adjustment on the exam. I know that there were a couple of questions that went through that I looked at a bit in hindsight and thought that was a little bit more complicated than was warranted on the exam. So don't be distraught. Push forward. I assure you, this is not the first time that I've taught the class. I'm aware of adjustments that sometimes need to be made, and I will adjust accordingly, particularly when you see scores that aren't as perhaps we would like them to be. That's not to say that there weren't some of you that did really, really well, and you're to be congratulated on that. But I know some of you were disappointed in the score on those objective questions. On exam number 3, which will be coming upon us shortly, which is devoted to the law of property, I hope that you'll have kind of the opposite response. Those of you that didn't do as well on 2, I think and hope will do quite well on exam number 3. Exam number 3, the property exam, is over the most objective material that we have in the course. I mean, the whole concept of property law is that we want there to be certainty. We want there to be no ambiguity with respect to who owns property, who has the right to use property. And so there are some concepts that we talked about during the first session that I want to review with you briefly before we press forward in the law of real property. But in sum, from the first discussion, it is important to understand that the law of property is the law of value, and that we actually, while we talk about property law as being a substantive area of law, it's really actually 2 substantive areas of law. And the second substantive part of it is even broken down into 2 parts. We have the law of real property, which we discussed is the law of the land and anything permanently affixed to the land. And then we have the law of personal property, which is really divided between that which is tangible personal property and that which is intangible personal property. And therein lies further subclassifications, the difference between money, stock, which are certainly intangible assets of value, and intellectual property, which I'll talk about in perhaps even as early as the next asynchronous session on the law of property. But our focus right now has been on the law of land, the law of what we refer to as real property, Mother Earth, if you will, and anything permanently affixed to the land. As we discussed, the owners of land is always or are always known. The ownership of land is a matter of public record. The government tracks the ownership of land. We know who owns land, and we have a fairly, I think, easy and nevertheless brilliant method of tracking the ownership of land in the United States by dividing property into townships, 36 square mile units of land that allow for ease in description of the location of land within those townships, and then a method of tracking ownership vested with the Register of Deeds office in a county within a state. We want there to be precision relative to who owns land, and this is, as I said, a process that is in the hands of government. We want to minimize disputes over who owns land, and we want the government always to know whom is responsible for the taxes to be paid on the ownership of land. When we look at the law of land, I think it is important to recognize that there are multiple issues that are important to have an understanding of as it relates to the law of real property, the law of land. The first issue is understanding the distinction, the difference between real property and personal property. The second issue is understanding that when one holds an interest in land, that is what we refer to as an estate in land. And that's what I covered during the first asynchronous session with you. But whenever one has the right to possess or use land, this is what we would refer to as an estate in land. And it may be ownership of the land, which is a fee simple estate or a conditional estate, or it may be just simply the right to possess land, such as most of you currently who hold a tenancy interest in property. And significantly, when you hold an interest in property, that property cannot be taken from you without due process of law. So if you have a tenancy in an apartment or the room in a house that you might rent on, say, Spartan Avenue, and you are not making your payment, before you can be evicted, before action can be taken against you, even if it's justified in taking that action against you, you are afforded due process of law. You are entitled to a court hearing to explain why it is that you, or give you an opportunity to explain why it is that you haven't made payment, why it is that you shouldn't be evicted. And even when there is an order of eviction, there's typically up to 7 days to give someone the opportunity to remove themselves from property. So anytime you have an interest, something of value that is characterized as being real property, that's going to fall into one of the 5 estates that we discussed during the first session on the law of property. Any interest in land is always established in written form. There is always going to be a contract, say a lease for your apartment. If it's an easement, it's going to be memorialized in the form of a written document defining that easement, or a court order defining that easement. If it is going to be ownership of property, it is typically going to be manifest in the form of a deed. There'll be a document that is proof of ownership that is recorded with the Register of Deeds office. So any interest in land is always established through what we refer to as, and this is a legal term, but color of title. And color of title is that document that you hold up that says, see, I have a lease interest, or I have an easement, or I have a life estate, or I own the property, or I own the property subject to a condition on how I am able to use the property. So the issue that is paramount, certainly in our first discussion of the law of real property, was the estates in land. Where we move now is to the third, if you will, issue of the law of real property, and that is how do we go about transferring ownership of property, and what we refer to as voluntary and involuntary methods of transferring ownership of property. We're then going to talk about when people hold their interests in real property collectively, jointly. What are the legal ramifications? What is the legal impact of holding an interest in property collectively, jointly? What happens if someone dies? What happens to their interest in property? What happens if the people don't want to hold their interest in property jointly any further or any longer? What happens if there is liability associated with that property? There's a lawsuit, somebody is injured on the property, or there are taxes that are owed on the property. Whom are the persons or person who is responsible for the payment of that debt? Finally, we'll then look at the limitations on the use of property, zoning limitations. And then we'll move ultimately into the discussion of personal property with the focus in on intellectual property. So we've talked about the estates and land, and we're now moving into our discussion of how do we actually go about transferring ownership of land from one person or entity to another. Now, in a state like Michigan, and frankly, any of the non-original 13 states, you can track ownership of land all the way back to the United States government. And in fact, it's interesting sometimes to actually go and look at a parcel of land and see the history of that land. And if you look at what we refer to as an abstract of title, you will actually be able to trace the ownership of land back to when the land was in the hands of the United States government. And what happened was that oftentimes the United States government would use the transfer of land to resolve certain debt that government had or owed individuals, or as an incentive for there to be Western expansion. Michigan was at one time viewed as being a Western state. And some of our land laws, even still to this day, reflect the history of the state being part of the new frontier, the Western frontier of the United States. Unlike with many other countries, notably countries in the East, once land is transferred to or out of ownership by the government, once it's transferred to private ownership, that private ownership remains in perpetuity. Obviously, as humans, we are not going to be around forever. And so we have the ability to transfer property, gift property, sell property, die and bequeath or devise property as we will. But there is no reversion of the property back to government as exists in many countries, particularly in the Far East, and China is principal amongst them. There is no reversion of ownership once that ownership passes into private hands. But what happens is that private owners of property have the ability to transfer their interest in property and to do so. And so we're going to move into our discussion of the methodology for purposes of the transfer of real property and how that occurs in the modern world. And with the aid of the lecture slides, I will advise you that transfers of land can occur both voluntarily and involuntarily. Now, the vast majority of the time that we transfer land, it's done voluntarily. I own my home. I decide that I want to sell my home and perhaps go buy other land, and that is a voluntary transfer of land. Or I decide to retire and I have more property than I need, and I decide to gift my land to Michigan State University, which, believe it or not, people do. And I would transfer my ownership interest voluntarily. Perhaps, and it's odd to think of a voluntary transfer of land occurring when someone dies, but perhaps someone dies owning land and under the terms of their will or through their trust, they dictate whom that land is to pass at the time of their death. That would be considered a voluntary transfer of land. Or when someone owns land jointly, say with their spouse, and dies, their interest in the property automatically passes to their spouse as a joint owner with survivorship rights. Those are all covered through what we refer to as voluntary transfers of land. But land can be transferred involuntarily. It can be removed from a property owner, their interest in land, through two legal means that we will talk about. One known as adverse possession, where someone loses their land by allowing another to openly use the land and claim it as their own for a sufficient period of time, 15 years in most jurisdictions or longer. And then we also see a method of government taking land involuntarily through the government's power of eminent domain. And we see certain projects, government paid for projects in which government uses its power of eminent domain to take land involuntarily from landowners. It would be next to impossible for a expressway to be built if the government didn't have the power or the authority to take land involuntarily. Of course, pay the landowners for that property, but that is a method of taking property not through voluntary means. The most common method of transferring land is through a legal device known as a deed. And this is how most property, most land is ultimately transferred. I own my home, 1234 Main Street. I decide to sell 1234 Main Street, and you wish to buy 1234 Main Street. We agree that I'm going to sell 1234 Main Street to you for $100,000. Now, I might owe money. I might have a mortgage that secures a loan that I have taken out on 1234 Main Street. And that loan is going to have to be paid off before I can actually transfer ownership to you. And I'm going to need the money that you're paying me to actually pay off the loan to be able to actually transfer title, ownership to you by deed. That's very common. It is also very, very common that you're not going to have $100,000 lying around to buy 1234 Main Street from me. So you'll go to a financial institution, you will borrow money to pay to me. I will use some of that money to pay off the debt that I have on 1234 Main Street. And I will transfer title. I will transfer ownership to you through a document known as a deed. A deed will describe the land that I am transferring to you. It will be signed by me. It will be dated, and ultimately it will be recorded with the Register of Deeds office in the county where the property is located, such that the world will now be on notice that I no longer own 1234 Main Street, but that you own 1234 Main Street. And again, the likelihood is going to be that you're going to have to borrow money to pay me that $100,000 for 1234 Main Street. And you're going to sign a promissory note, which is a contract obligating you to repay the financial institution the money that you borrow. And that promissory note, that promise, that contract to repay the money that you have borrowed, is going to be secured by a mortgage. And a mortgage is an agreement between the borrower and the lender that would allow for the lender to take the land without going through a court case, without going through a judicial process. And the process of the lender taking the land to satisfy or partially satisfy the money, the debt that is owed, is what we refer to as a foreclosure. And it's the mortgage that allows for the foreclosure to take place. When one borrows money and uses land as the collateral for that loan, this is what we refer to as secured debt. The security is the mortgage, and the mortgage is the security for the debt because it allows for the lender to take the property in satisfaction or partial satisfaction of the debt that is owed. Much of borrowing is unsecured. You may be borrowing money, likely most of you are borrowing money to obtain your degree. You signed a promissory note. You agreed to repay the money that you are borrowing at an interest rate, but that is what we refer to as an unsecured debt. Your credit score can and will be affected if you don't make repayment or if you fall behind in your repayment on that debt. But it would necessitate a lawsuit being filed against you and a judgment entering against you for the lender to be able to actually take assets of yours to pay that debt. Secured debt, on the other hand, allows for a creditor to take the asset without going through the process of going to court and obtaining a judgment. Those of you that have borrowed money to purchase a vehicle certainly recognize that if you don't repay or make payment towards that vehicle, that somebody's going to come and repossess that vehicle. They're going to take that vehicle. That is a security on the loan that allowed for you to actually walk away with that vehicle. That's the concept of the note and the mortgage that secures the note. And I will give you, and I try not to give a lot of legal advice in teaching the course, but I will give you what I think to be an important thing to remember, because a good number of you in the next decade are going to be out in the market looking to buy a condominium or looking to buy a house. And I will give you what I think to be sound advice, and that is, if you cannot put up 20% towards the purchase of real property, pass. Don't borrow more than 80% of the cost when you are acquiring land. The loan over time becomes appreciably more costly, expensive, because of different types of insurance that are required of you when you are borrowing more than 80% of the value of the property. So for what it's worth, if you can't come up with 20% of the value of the property on the downstroke when you're purchasing the property, go buy something else or pass, or wait until you can have at least a 20% equity in the property at the time that you buy it. That's my advice to any young first-time property owner. And no one's ever come back and complained about that advice, at least in folks that I've represented through the years, because they've not gotten themselves in economic difficulty, which can happen when people borrow too much money and don't have a significant enough equity in the property. Now, when you borrow money, close, get a deed, sign a promissory note secured by a mortgage, you're the owner of the property. It is yours, but it is yours subject to a lien. That lien being the mortgage, the obligation for there to be repayment, or the risk that you lose the property through a foreclosure. But you are the title holder. It is yours, subject to the obligation to make payment on the loan. I remember closing on my house and everybody congratulating me about being an owner of land, and all I could think about is, great, I have my name as the recipient, as the grantee on a deed, and after 360 easy payments to the MSU Federal Credit Union, it'll actually be mine. It was a somewhat hollow feeling of ownership. There is also the ability for the acquisition of land from the seller. The purchaser can pay the seller over a prolonged period of time, where the seller retains title and there is no lender other than the seller themselves. This is a concept known as a land contract. I own 1234 Main Street. You wish to buy from me 1234 Main Street. Maybe you're a family member. Maybe you're an employee of mine. Maybe you just can't really come up with enough money or won't qualify for a loan through a financial institution. But I want you to have 1234 Main Street and you want to buy it. So we might enter into a land contract. I hold title, but you are actually paying me over time, and you will possess the property while you are making those payments. At the conclusion of the land contract, I will then transfer to you title by deed, and the property will be yours. Now, whenever there is a promissory note, whenever there is a land contract, or in other words, whenever there is payment over time to acquire property, you have to be cognizant. You have to be aware of two things by my way of thinking. One is this an adjustable rate obligation? In other words, are you agreeing to pay a percentage rate on the loan that is going to be variable? Because over the course of the next few years, certainly, I think you're going to see those variable rates tick up rather than go down, as has been the case over the better part of the last 20 years. And so you could lock yourself into a rate that then goes higher over the course of the early period of the loan, and that can be problematic. So be aware of, is the interest rate that you're going to be repaying the loan something that is going to remain fixed, or is it going to be something that is going to be adjusted? If it seems too good to be true at the beginning, then it's probably too good to be true. The other thing to be aware of, the other thing to look for, is what we refer to as a balloon clause. A balloon clause is a provision within a loan document that calls for the full loan to be due premature as opposed to the amortization schedule. Now, whenever you borrow money, there's usually a time frame within which the repayment will occur. I referenced a 30-year mortgage, 360 payments to the MSU Federal Credit Union, all of them of the same amount of money. But what happens oftentimes, and you'll see this almost always in land contracts, is you'll see a provision in the loan documents that will call for the entire loan to be owed at a time frame that is much earlier than called for under the amortization schedule. So we call for 360 easy, even payments, but then there's a provision in the loan document that says, but nothing in this agreement shall be construed as to allow the loan to not be repaid in 5 years' time or less. Or in other words, whatever the terms of the agreement call for, 5 years from today's date, or 3 years from today's date, or 10 years from today's date, the full amount of the loan is owed. That's what we call a balloon clause. And what it does is it forces refinancing of the property at a premature time frame, as opposed to the amortization period. All land contracts that lawyers draft contain some form of balloon clause. Looking at the two types of involuntary transfers of property. The first of the Involuntary transfers of property is what a process of involuntary transfer of land that we refer to as adverse possession. Now, this may seem a bit contrary to fairness doctrine, but I assure you it is not. Under the doctrine of adverse possession, if someone uses property openly, notoriously, meaning without the permission of the property owner, continuously for the statutory period of time for adverse possession, which in Michigan and in most states is 15 years, then the person who has openly and continuously and notoriously used the property now owns it. The transfer occurs through the doctrine of adverse possession. Now, before you think about, well, I'm going to just go out onto my neighbor's lawn and fence in, you know, a 10-foot area, and after 15 years, I'll own that 10-foot area. The reality of it is people don't like those of their neighbors who are trying to trespass upon their property. They'll bring an end to it well before you get to the 15-year time frame. Really, what adverse possession is used for primarily is to minimize the likelihood of property line disputes, because property line disputes could happen with great frequency, but for the doctrine of adverse possession. You move on to property. There's a fence up. A few years after you move on to that property, you have a survey done of your property because maybe you want to have an addition placed onto your property, or you just want to know what is the actual property line. And sure enough, you find out that the fence is not precisely where the property line is, at least according to your survey. Well, if that fence has been there for 15 years, guess where the new property line is? It's where the fence line is. If property is used openly, continuously, notoriously for 15 years or more, that property becomes the property of those who have been using that property for that open, continuous, notorious 15-year period. And yes, the fact that you are new to the property doesn't change or alter the 15-year time frame. We allow for what we refer to as tacking, by property owners moving from the property, having the property used in a particular condition, and the new property owners coming on, and the time frame continues. We don't restart the clock simply because there is a change of ownership of the property. You might say, how do you prove that the property has been used openly, continuously, and notoriously for 15 years? It's amazing what old photographs will show. I have photographs of my daughter's 5-year-old birthday party. In the back of those photos, there are shrubs that kind of separate our house from our neighbor's house. My daughter is 32. And so if somebody were to question, hey, how long have those shrubs been there? I could show the photographs. And that's oftentimes how we establish the time frame through and when the issue of adverse possession arises. Adverse possession actually reduces the likelihood of property disputes rather than increases them. About a couple times a year, people will call me and they'll ask me a question about, you know, the property line between their property and their neighbor's property. And I'll ask for, is there a fence? Is there shrubbery? Is there a driveway? And then the question becomes, how long has the property been used in the condition that it is currently being used? And if the answer is 15 years, 20 years, 30 years, oh, it's always been this way, well, then there is no property dispute, property line dispute moving forward. The next method of involuntary transfer of property is what we refer to as the government's use of the power of eminent domain. If the government wants to acquire land, it's very difficult for the government to go out and be a market participant. Why? Because if I know the government wants to extend I-75 and they have to extend it through my farm yard or field, then I'm not going to be willing to sell my farm land to the government for the extension of I-75, and I'm going to hold out for the most amount of money that I can ever get. We do not want the government to have to bid against private property owners when it's in the public interest that property be acquired by the government for some public benefit. And so from the very earliest days, we have vested in government the authority or the power of eminent domain, the ability for the government to take private property for public use. Part of the doctrine of eminent domain is that the private property owner who is losing the property is to be adequately, fairly compensated for the property that is being taken. And this is a process known as a condemnation proceeding. It's a judicial proceeding to determine what's the fair value to pay someone whose property is being taken by the government through the government's power of eminent domain. Now, back prior to the 1970s, when we thought about the utilization of the government's power of the eminent domain to take land away from private property owners, it was almost always for some public usage of property, such as schools, roads, libraries, government buildings, including jails and courthouses. But beginning with a very famous case involving the city of Detroit and the Poletown development and the community in which property was taken to ultimately transfer to an automobile manufacturer. You see the photograph here with Comerica Park, where the Downtown Development Authority for the city of Detroit went about using its power of eminent domain to take land, to ultimately transfer that land back into private ownership, the Detroit Tigers. There is the argument, and this is an argument to which people have strong opinions both ways, that there is a public benefit that can be derived by the government taking property and still then using that property for private use. So in other words, they take my privately owned property, they transfer it to you because there is the belief that you will be able to generate more public benefit through the method in which you intend to use the property as opposed to how I was using the property. Again, you can see where this is something that has been subject to great debate and will continue to be subject to great debate. But the key principle is there public benefit, and what is that public benefit? An example of the transfer of property through the method of the government's power of eminent domain. Next up in discussing the law of land is the fact that you can have two or more people who have the same interest in land at the same time. This might be children inheriting property from a parent who has died. This might be a married couple who acquires land together. And when you have joint ownership, concurrent ownership of land, this creates three legally significant issues that we need to understand. One is what happens to the interest in property when the first owner dies. I'm going to defer the answer to that question to our next session, where I will be addressing wealth transfer at death. In sum, you have to understand the legal relationship between the two owners of the land to get to the right answer. Marriage is the key. Two people who are married to each other, one dies, they own their property jointly. there's a presumption of survivorship to the surviving spouse. Two people own property together and one of them dies and they're not married to each other. There is not a presumption of survivorship relative to the land. But we'll talk about that as we move forward in our overview of the law of property. With respect to, can people be forced to own property against their will together? The answer is no. You can file what is referred to as a partition action, and a court can order the division of the property, the sale of the property, but allow people to not hold property jointly if they wish not to do so. And then the third issue is, what about liability? You have two or more people that own property together, and there is a judgment based upon the property. It might be for a tax, a lien, and in any form of monies that are owed on that property. The answer very simply is all of the property owners collectively and individually are responsible for the debts associated with that property. All property owners collectively, jointly, and individually are fully responsible for the debt associated with that property. We're going to talk about joint and several liability a little bit more when we look at business associations, but it is a concept that very much permeates the concept of property law, and we'll continue to talk about that as we move forward as well. The last issue relative to the law of real property that I want to address with you in this session is the limitations that we place on the use of real property to benefit the property and contiguous properties. And these are what we refer to as zoning ordinances. You know, if you ever fly over land, you can look down from the airplane and recognize that, you know, we kind of put residential areas in one part of a community and agricultural use of property in a different area. And there's the commercial center, there's the industrial or agricultural centers of the community. And the idea behind this is that there is some value in concentrating the use of property and in limiting the use of property. You build your dream home. You want to be able to invest and build that dream home, secure that a hog farm isn't going to be established, you know, right in your backyard, or that an industrial chemical plant isn't going to be built, you know, right across the street from where you've built your dream home. We recognize that certain businesses are incompatible with being in close proximity to a school or to a church. And so there are in certain communities what are referred to as the red light districts, where you might have, you know, adult entertainment businesses. And those are going to be, you know, limited in where those types of businesses are going to be permitted for obvious reasons. Zoning has many components to it, but the whole concept, the whole idea, the whole purpose is that we want people to have a fair assessment of how property will be permitted to be used before they spend the money to actually buy that property. Is it possible to get variances or permission from the government to use property other than how it is zoned? The answer is yes. But if you're going to buy property with the intent or the objective to use the property other than how the property is zoned, you probably want to get that. You're probably going to want to get that permission well in advance to make sure that you're not overpaying for property and finding that you're not able to use the property as you had hoped, as was intended. I think that's good for a second asynchronous session of the law of real property. There's more to go as it relates to property, including, as I mentioned a moment ago, what happens when somebody dies owning an interest in land. And so we'll talk about wealth transfer at the time of death, including the transfer of real property at the time a person dies. Hopefully that's not something that's going to involve any of you for a long time, but it's important to have a working knowledge of the transfer of assets at the time someone dies, so that when you ultimately have the need for estate planning as you grow older, you'll recognize there's nothing magical or difficult about it. And also when you address and face these issues, when grandparents or parents of yours pass away, you'll have a working knowledge also of wealth transfer at the time of death. I'm available to you as much as you need me to be. Come by office hours, stop by Zoom on office hours if that will help you. Reach out by email. We are here to serve you. That's why the university exists.